understanding that a plea has to be entered after or during an arraignment, which an examining trial is not. An arraignment is something completely separate. So, why are they taking a plea in an examining trial in subsection A? Because subsection B is saying that you have to be told when to come back to go to arraignment, which is where you normally enter your plea. Now, I went and looked up arraignment. And guess what? An arraignment actually only occurs after an indictment. Okay? You get that? An arraignment occurs after an indictment. Well, you're not being indicted. So an arraignment would not apply in the case of a Class C misdemeanor. So what are they sending you for on an arraignment? Because the code says only in the case of an indictment is an arraignment to be held. So where does that leave us? Well, when you go through this, the order must state in writing. Now we're back in 1517B. We're continuing on. The judge has to, the magistrate may release the accused without bond and order the accused to appear at a later date for arraignment. The order must state in writing the time, date, and place of the arraignment. And the magistrate must sign the order. The accused shall receive a copy of the order on release. I don't know about you, but I don't ever get a copy of any order when I leave a traffic court. If an accused fails to appear as required by the order, the judge of the court in which the accused is required to appear shall issue a warrant for the arrest of the accused. If the accused is arrested and brought before the judge may admit the accused to bail. And admitting the accused to bail, the judge should set as the amount of bail an amount double that generally set for the offense for which the accused was arrested. This subsection does not apply to an accused who has previously been convicted of a felony or a misdemeanor other than a misdemeanor punishable by fine only. All right? Now, let's skip down a little bit to subsection E. All right? In each case in which a person arrested is taken before a magistrate as required by subsection A record shall be made of 1. The magistrate informing the person of the person's right to request appointment of counsel. Aren't you automatically told in traffic court that they don't appoint counsel, they're not going to appoint counsel, and you need to get your own counsel? And if that's the case, wouldn't that mean that they are either A, ignoring the procedure set forth in subsection A of 1517, or there's something there's not telling you about where you're actually supposed to be? Because here this says that you have the right to request appointment of counsel under subsection A. So if they're following the procedures of subsection A, they should be telling you that, and they're not. In fact, they're denying you counsel. Now, let's go to 2. The magistrate asking the person whether the person wants to request appointment of counsel, and, subitem 3, whether the person requested appointment of counsel. Well, this all seems pretty clear to me. Here are 3 things they must document about the appointment of counsel. Nowhere here does it say the judge must document that the judge denied the appointment of counsel or that the judge denied the opportunity to request appointment of counsel. It just simply says that on these 3 things, the documentation shall be made that the person was told about the appointment of counsel and whether or not they wanted to request appointment of counsel and whether or not the person did request appointment of counsel. Very odd, don't you think? Now, subsection F. A record required under subsection E may consist of written forms, electronic recordings, or other documentation as authorized by procedures adopted in the county under Article 26.04A of the Code of Criminal Procedure. Now let's go to G. G is where this gets interesting for us. If a person charged with an offense punishable as a misdemeanor appears before a magistrate in compliance with a citation issued under Article 1406B or C, the magistrate shall perform the duties imposed by this article in the same manner as if the person had been arrested and brought before the magistrate by a peace officer. After the magistrate performs the duties imposed by this article, the magistrate, except for good cause shown, may release the person on personal bond. If a person who was issued a citation under Article 1406C fails to appear as required by that citation, the magistrate before which the person is required to appear shall issue a warrant for the arrest of the accused. Now, why is this important? Well, because 1406B and C say they apply only to a citation issued for Class C misdemeanors other than an offense under Section 4902 Penal Code that deal with things listed and enumerated in this code, meaning the Code of Criminal Procedure. Well, do you know what is not back here anywhere? Anything dealing with jurisdiction of transportation code offenses. There's nothing there. There's all kinds of offenses listed for statute of limitations and jurisdiction. Just no transportation code. Now, why is that? Now, let's also analyze what they do under 543 Transportation Code. 543 Transportation Code has a very specific set of instructions on what the officer is to do. 543.002, person arrested to be taken before a magistrate. A person arrested, or subsection a person arrested for a violation of this subtitle. Now get this subtitle, that would be subtitle C. Okay? Punishable as a misdemeanor. Notice it did not say Class C misdemeanor, it said misdemeanor. Shall be immediately taken before a magistrate if, 1, the person is arrested on a charge of failure to stop in the event of an accident causing damage to property. Or, 2, the person demands an immediate appearance before a magistrate or refuses to make a written promise to appear in court as provided by this subchapter. Subsection B, the person must be taken before a magistrate who, 1, has jurisdiction of the offense, and 2, is in the county in which the offense charged is alleged to have been committed, and 3, is nearest or most accessible to the place of arrest. So just because you get a ticket and arrested in the city does not necessarily mean that the municipal court gets jurisdiction. They're required to take you to the nearest magistrate in the county where the arrest takes place. It says in 3, is nearest or most accessible to the place of the arrest. So it's very clear there. They don't have the 48-hour option under 1406, and it's not really an option. They just like to claim it is. Now think about that. 543 says they are to immediately take you to a magistrate. They are arresting you based upon a transportation code offense. Therefore, they are bound by the procedure of the transportation code, not the Code of Criminal Procedure. The transportation code says to take you immediately to a magistrate. 1406 says to take you as soon as possible without unnecessary delay, but no more than 48 hours. So what they're doing is they're switching from 543 to 1406 as a matter of convenience to the officer and to the magistrate, which flies in the face of the violation. But now the problem this raises, if the Class C misdemeanor under 1406 has to do with offenses issued under charges over which there is jurisdiction in 1406 and the transportation code is not there, then the procedures of 1406 don't apply. And since you are being arrested without a warrant, you would presume the procedures of 1406 would have to apply. But here's the problem. Texas Administrative Code specifically states that any offense under the jurisdiction of the Department of Transportation or under the jurisdiction of the Department of Public Safety, except for those specifically omitted in 521, 522, 548, or 524 and 724.